Thank you, Mr. Chairman. Dr. Noss, you've mentioned several times today that it's been amazing that the ESA has been as successful as it has been. Why do you keep repeating that? Can you explain can you further elucidate us on what you mean by that?
What I mean is very simply that the threats that led to those species being listed in the first place have not abated, and most of them have actually gotten worse since the Endangered Species Act was passed and those species were listed. So the other part of the question is that we haven't had the money given to the Fish and Wildlife Service and the National Marine Fisheries Service to recover species as the Act at least intends in spirit. It doesn't give clear guidance, as Mr. Parendell mentioned.
So you're asking for more money. Could the answer just be that nature takes care of itself, that maybe we don't know more than nature does? You know, your answer is to come from up on top telling nature what it needs to do and telling humans what they need to do, as opposed to just realizing, like Mr. Costa just asked, that some species are going to go and some species are going to stay. And that's just a regular evolutionary process. And that you don't know more than everybody else.
This is way out of the ballpark of natural evolution.
Yeah.
It's basically, you know, nature is still out there, but it's been overwhelmed by the human population and our consumption.
Okay, you said, according to the website Warrior Society, you made a statement on June 19, 2004 that, quote, the collective needs of non-human species must take precedence over the needs and desires of humans, unquote. Do you still stand by that?
I do.
Mr. Parento, in a 1998 William and Mary Law Review article entitled, quote, Rearranging the Deck Chairs, Endangered Species Act Reforms in an Era of Mass Extinction, you wrote that, quote, humanity threatens to turn the earth into a planet of weeds, unquote. Do you still stand by that statement?
That's what the science suggests.
That's what the science suggests. And have either of you received or represented plaintiffs that have received attorney's fees paid for by the federal government?
I have.
Have I received what?
Payments or represented plaintiffs that have received attorney's fees from the federal government?
No.
How many ESA lawsuits have you personally been party to, Mr. Parento?
Representing interests?
Yeah.
Didn't do a calculation before I came here, but
approximately.
Over 40 years? My goodness. 20?
Okay, Mr. Parento, will the Center for Biological Diversity or any other groups you represent endorse any legislation that would require public disclosure of the amount of money it receives from taxpayers through EG and the Judgment Fund?
That was for me?
Yes.
I didn't get the question. Do they have to report it? Yes, it's 501c3 1099 form.
And they report currently how much money they receive from the federal government?
Yes, they do.
Okay. In 2004, you authored an article for the Duke Environmental Law and Policy Forum entitled Anything Industry Wants, Environmental Policy under Bush II, in which you lamented that the Bush administration was using sweetheart deals routinely to make major policy decisions without public participation and congressional review. You remember that article, I assume?
I certainly do.
You say as much in your testimony that sue and settle, but today you're saying that sue and settle is an old story. Yet I'm wondering why you decry this tactic in one instance and you defend it in another instance.
I decry it in both. And some of the sweetheart deals in the Bush administration were turned aside by the courts. So that was my reason for saying that I don't think you can charge the courts with an act of collusion in these cases. One case in particular involving wilderness study areas in Utah comes to mind, and there was a sweetheart deal. There was no public participation, and the Bush administration was about to cede federal rights to millions of acres of land in an agreement that was about to be entered by the court. Environmental groups got wind of it, intervened, and stopped it. So I'm consistent in saying I don't think the courts are handmaidens in implementing sweetheart deals engineered by interest groups on either side, whether it's industry or environmental groups. I don't think the courts
shouldn't the states and citizens that will actually have to bear the burden of these litigations and these listings have an opportunity to weigh in on these decisions?
They have that opportunity.
Now, do you feel that this administration's, going back to the Utah example that you just raised, do you feel that this administration's interior settlements with CBD and WEG without any public involvement are similarly outrageous, or that they constitute the camel's nose under the tent, as you have said about the Bush administration?
No, because those agreements set a timetable for decision-making. They make no decisions whatsoever about whether species will be listed or not. There will be ample opportunity for public review and comment in the rulemaking process that has to be done for each and every one of the species.
So when the ultimate decision is in accordance with your stated views, then it's okay, but when it's not in accordance with your stated views, then it's not okay.
Well, that's a misrepresentation of what I said.
Time of the gentleman